pre-trial is a procedural device intended to clarify and limit the basic issues between the parties. It thus paves the way for a less cluttered trial and resolution of the case. Its main objective is to simplify, abbreviate, and expedite the trial or dispense with it.
Jurisprudence considers a pre-trial to be one designed to narrow and clarify the basic issues between the parties, ascertain the facts relative to the issue, and enable the parties to obtain the fullest possible knowledge of the issues and facts before civil trials, and thus prevent the said trials to be carried on in the dark.
A pre-trial is not only intended to clarify and limit the basic issues between the parties, it also takes the trial of cases out of the realm of surprise and maneuvering. Babe, you're finally here. How's the travel? You look tired.
Same old Philippines. Traffic's horrendous.
Okay, so everything's settled. I've already talked to the organizers, the restaurant for the reception, the videographers. Oh, and I've already wired the down payment. Yeah, and about the plane tickets, I've already booked for those who are abroad. Oh, babe, about the flowers.
Babe,
Yes, babe?
we need to talk. I've been thinking about this a lot, but there's no gentle way to say this. The wedding, I think I need to call off the wedding. I've been having a second thoughts and realize I'm not quite really sure for the next chapter of our lives. I'm very sorry. Section 1, Rule 18 of Rules of Court provides when a pre-trial is conducted. It is conducted after the last responsive pleading has been served and filed. The branch clerk of court shall issue, within 5 calendar days from filing, a notice of pre-trial, which shall be set not later than 60 calendar days from filing of the last responsive pleading.
Ms. Garcia, all the pleadings has been served and filed. We'll now be moving to the pre-trial stage.
What is that, attorney? Is it similar to what I've seen on TV shows? Are we entering the exciting part already where Popoy will be put on the stand to answer questions?
Not yet, but a pre-trial occurs before the trial itself. Its purpose is to prepare both parties, trial, and to facilitate the efficient and fair resolution of the case. So that is the exciting part. Like what you said, happens during the trial, not the pre-trial. According to Section 2, Rule 18 of the Rules of Court, the pre-trial is mandatory and should be promptly terminated.
Section 2, Rule 18 of the Rules of Court, pre-trial is where the court shall consider: A. the possibility of an amicable settlement or of submission to alternative modes of dispute resolution. B. The simplification of issues. C. The possibility of obtaining stipulations or admissions of facts, a read of documents to avoid unnecessary proof. D. The limitation of the number and identification of witnesses and setting of trial dates. E. The advisability of a preliminary reference of issues to a commissioner.
F. The propriety of rendering judgment on the pleadings or summary judgment or of dismissing the action should a valid ground therefore be found to exist. G. The requirement for the parties to 1. Mark their respective evidence if not yet marked in the judicial affidavits of their witnesses. 2. Examine and make comparisons of the adverse parties' evidence vis-a-vis the copies to be marked. 3. Manifest for the record stipulations regarding the faithfulness of the reproductions and the genuineness and due execution of the adverse parties' evidence. 4. Reserve evidence not available at the pretrial, but only in the following manner. 1. For testimonial evidence, by giving the name or position and the nature of the testimony of the proposed witness. 2. For documentary evidence and other object evidence, by giving a particular description of the evidence. No reservation shall be allowed if not made in the manner described above.
H. Such other matters as may aid in the prompt disposition of the action. The failure without just cause of a party and counsel to appear during pretrial, despite notice, shall result in a waiver of any objections to the faithfulness of the reproductions marked, or their genuineness and due execution. The failure without just cause of party and or counsel to bring the evidence required shall be deemed a waiver of the presentation of such evidence. The branch clerk of court shall prepare the minutes of the pretrial, which shall have the following format.
After that, the court will send a notice of pretrial. I will just inform you of any updates regarding this case.
All the best, attorney.
Section 3, Rule 18 of the Rules of Court provides for the notice of pretrial. The notice of pretrial shall include the dates respectively set for the pretrial, court annex mediation, and judicial dispute resolution if necessary. The notice of pretrial shall be served on counsel or on the party who has no counsel. The counsel served with such notice is charged with the duty of notifying the party represented by him or her. Non-appearance of any of the foregoing settings shall be deemed non-compliance of the pretrial and shall merit the same sanctions under Section 5 hereof.
Section 6. Pre-trial brief. The party shall file with the court and serve on the adverse party in such manner as shall ensure the receipt thereof at least 3 calendar days before the date of the pre-trial. The respective pre-trial brief which shall contain, among others, failure to file pre-trial brief shall have the same effect as failure to appear at the pre-trial.
Miss Basha, you seem so tense. Are you okay?
I don't know, attorney. No, after all those unforgettable and sweet moments we shared, I didn't expect things to end up like this.
Compose yourself, Miss Basha. This will be over before you know it. The only circumstances excusing us from pre-trial are acts of God. Or if you're physically unable to attend the hearing, since you're already here, let's do our best. Okay?
Section 4, Rule 18 of the Rules of Court. Appearance of parties, it shall be the duty of the parties and their counsel to appear at the pre-trial, part annex mediation, a judicial dispute resolution if necessary, the non-appearance of the party and counsel may be excused only for acts of God, force majeure, or duly substantiated physical inability. A representative may appear on behalf of party but shall be fully authorized in writing to enter into an amicable settlement, to submit to alternative modes of dispute resolution, and to enter into stipulation or admission of facts and documents.
Section 5. Effect of failure to appear. When duly notified, the failure of the plaintiff and counsel to appear without valid cause when so required shall cause the dismissal of the action. The dismissal shall be with prejudice unless otherwise ordered by the court. A similar failure on the part of the defendant and counsel shall be caused to allow the plaintiff to present his or her evidence ex parte within 10 calendar days from termination of pre-trial and the court to render judgment on the basis of the evidence offered.
Section 7, Rule 18 of the Rules of Court provides for the pre-trial order. Upon termination of pre-trial, the court shall issue an order within 10 calendar days which shall recite in details the matters taken up. The order shall include the direct testimony of witnesses for the plaintiff shall be in the form of judicial affidavits. After the identification of such affidavits, cross-examination shall proceed immediately. Postponement of presentation of the parties' witnesses at a scheduled date is prohibited, except if it is based on the acts of God, force majeure, or duly substantiated physical inability of the witness to appear and testify. The party who caused the postponement is warned that the presentation of its evidence must still be terminated within the remaining dates previously agreed upon. Should the opposing party fail to appear without valid cause, stated in the next preceding paragraph, the presentation of the scheduled witness will proceed with the absent party being deemed to have waived the right to interpose objection and conduct cross-examination. The contents of the pretrial order shall control the subsequent proceedings unless modified before trial to prevent manifest injustice.
Section 8. Court Annex Mediation. After pre-trial and after issues are joined, the court shall refer the parties for mandatory court annex mediation. The period for court annex mediation shall not exceed 30 calendar days without further extension. Previously, court annex mediation precedes pre-trial proper, but the new provision reversed the steps to save time.
The Supreme Court en banc in its resolution dated October 16, 2022, AM number 1-10-5-SC-FILCHA, regards mediation as part of pre-trial, where parties are encouraged to personally attend the proceedings. The personal non-appearance of a party may be excused only when the representative who appears on his behalf has been duly authorized to enter into a possible amicable settlement or to submit to alternative modes of dispute resolution. To ensure the attendance of the parties, the court can impose sanctions upon a party who fails to appear in the proceedings, which includes censure, reprimand, contempt, and even dismissal of the action in relation to Section 5, Rule 18 of the Rules of Court.
In all civil cases and criminal cases covered by mediation, the judge issues a referral order incorporated in the pre-trial order, referring the parties to the Philippine Mediation Center or PMC for the mediation of their disputes by trained and accredited mediators. A referral to court annex mediation is made after the pre-trial conference in civil cases and after the pre-trial and preliminary conference of cases covered by mediation in criminal cases. During court annex mediation, the mediator explains to the parties the court annex mediation process and its benefits to the pending case. The mediator may hold separate caucuses for each party to determine their respective real interests in the dispute and hold joint conferences to resolve the dispute through reciprocal concessions.
Section 9. Judicial Dispute Resolution. Only if the judge of the court to which the case was originally referred is convinced that settlement is still possible, the case may be referred to another court for judicial dispute resolution. The judicial dispute resolution shall be conducted within a non-extendable period of 15 calendar days from notice of failure of the court-annexed mediation. If judicial dispute resolution fails, the trial before the original court shall proceed on the dates agreed upon. All proceedings during the court-annexed mediation in the judicial dispute resolution shall be confidential.
Section 2, Chapter 1 of AM number 19-10-20-SC provides that the following cases may be referred to JDR. JDR is conducted within a non-extendable period of 15 days. Number 1, from the receipt of referral order, or number 2, written manifestation of the parties in several sessions if necessary. In that period, the JDR judge sequentially becomes a mediator, conciliator, early neutral evaluator, in continuing effort to secure a settlement.
As a mediator and conciliator, the judge facilitates the settlement discussions between parties and tries to reconcile their differences. As a neutral evaluator, the judge assesses the relative strength and weaknesses of each party's cases and makes a non-binding and impartial evaluation of the chances of each party's success in the case. Based on his neutral evaluation, the judge persuades the parties to reconsider their prior reluctance to settle their case amicably. Thereafter, whether or not parties agreed to settle amicably, the judicial dispute resolution judge returns the case to the referring court for appropriate action.
Cases not referred to CAM-JDR. Section 4, Chapter 1 of AM number 19-10-20-SC provides that the following cases shall not be referred to CAM-JDR. In cases covered under paragraphs A and D, where the parties inform the court that they have agreed to undergo mediation on some aspects thereof. For example, custody of minor children, separation of property, or support pendente like. Court shall refer them to mediation.
Section 10, Rule 18 of the Rules of Court, Judgment after Pre-Trial. Should there be no more controverted facts or no more genuine issues as to any material fact or an absence of any issue, or should the answer to fail to tender an issue, the court shall without prejudice to a party moving for judgment on the pleadings under Rule 34 or summary judgment under Rule 35. Motu proprio include in the pre-trial order that number 1, the case be submitted for summary judgment, or number 2, judgment on the pleadings without need of possession, paper, or memoranda. In such cases, judgment shall be rendered within 90 calendar days from termination of the pre-trial. The order of the court to submit the case for judgment pursuant to this rule shall not be the subject to appeal or certiorari.
Babe, you're finally here. How's the travel? You look tired.
Same old Philippines. Traffic's horrendous.
Okay, so everything's settled. I've already talked to the organizers, the restaurant for the reception, the videographers. Oh, and I've already wired the down payment. Yeah, and about the plane tickets, I've already booked for those who are abroad. Oh, babe, about the flowers.
Babe,
Yes, babe?
we need to talk. I've been thinking a lot about this. There's no gentle way to say this. The wedding, it's just kidding. After all we've been through, it made me realize how much I truly love you. I apologize for my past behavior, even to the extent of calling off our wedding. I wasn't in the right state of mind, and I take full responsibility for my mistakes and earnestly hope we can learn from them and avoid repeating them in the future.
Me too, babe. I owe you an apology as well. My anger consumed me and all I wanted was to get back at you. Frankly, I'm grateful for the pretrial process in our justice system. It showed me how messy things can get if we proceeded with ongoing trials without proper consideration.
I agree with you, babe. Thankfully, those troubles are in the past now. I can't imagine losing someone as cute and as sweet as you.
Babe, before we delve into drama, I invited the third party to express our deepest gratitude. Without him, none of this would have been possible.
So, how are you? How are things? I hope everything's better now.
Thank you, attorney. Things are much better now, and it wouldn't have been possible without your help.
Yes, thank you, attorney, for helping me realize what was at stake with just one pre-trial.
Yeah, you're welcome, you're welcome. My pleasure. My role was simply advocate for my clients' rights and wishes. Thanks to our judicial rules and procedures, especially during the pre-trial phase, parties have the opportunity to reconciliation. From here on, I hope everything continues to improve. Okay? So, good luck.
Absolutely, attorney.
Attorney, I wanna file a divorce.